Dictation start. Section 409 provided that every criminal appeal shall be made in the form of a petition in writing presented by the appellant or his pleader, and every such petition shall be accompanied by a copy of the judgment of the trial court. Stop. Section 420 deals with appeals of convict persons who are in jail. Stop. They are to present their petitions for appeal to the officer in charge of jail, who is to forward such petitions to the proper appellate court. Stop. The word summarily ordinarily means in an informal manner and without the delay of formal proceedings. Stop. The judge is entitled to reject the appeal without any formality at all and without the formality of either a recorded judgment or reasons of any description. R.A.S. Baljit Singh versus Bal Gopal Singh, 21, Calcutta 92. Stop. Para. The appellate court is not bound even to call for the record, and there is nothing to prevent even those appeals being rejected summarily wherein substantial points of law have been taken, or where the judgment under consideration is a long and intricate one requiring careful consideration. Stop. A court of criminal appeal, when dismissing an appeal summarily, is not bound to write a judgment as defined in Section 367. Stop. The high courts have, however, advised and in some cases ordered the lower appellate courts to give as concisely as possible the main reasons of rejection of appeal summarily. Abdul Ahmad versus Sheikh Ansari, AIR 1933, Calcutta 515. Ganesh Dubey versus Gyanchand Dubey, AIR 1935, Patna 32. Stop. But the discretion of an appellate court remains unfettered in this respect, and where the only order passed was rejected summarily, it has been held that it was a judgment. Stop. Then an order of a high court in its criminal jurisdiction is ordinarily final and does not therefore require the statement of any reason. Kuldeep Das versus Emperor, AIR 1933, Patna 38. Stop. Para. In the Bombay case Nandlal Chunilal versus Emperor, the facts were that a reference was made by the Sessions Judge under Section 438 recommending that a particular order of additional district magistrate should be set aside, and thereon a division bench, without issuing notice, passed an order viz. No order on this reference. The applicant at whose instance the Sessions Judge made the reference then came in revision to the High Court in the same matter. Stop. The question before the full bench, consisting of Kaul, Mehta, Chaturvedi judges, was whether the order no order on this reference was a judgment within the meaning of Section 369. Stop. The full bench held that as there is no distinction between an order and a judgment of a high court disposing of a proceeding before it, the said order was a judgment under Section 369 and as such cannot be altered or reviewed. Stop. In the absence of anything to show that the order was passed on a preliminary ground without going into the merits. To the point raised in the reference, it must be presumed that the order was a final order and amounts to a judgment. Stop. Para. The proviso to section 421 of course lays down that no appeal under section 421 shall be dismissed without giving to the appellant or his pleader an opportunity of being heard. Stop. But there is nothing in the section to indicate that the legislature wanted that prisoners should also be afforded the same opportunity. Stop. In Bharat Singh versus Emperor AIR 1938 Bombay 279. Stop. Deepak Mishra, Chief Justice, was of opinion that the general rule that no person should be condemned unheard cannot apply to an appeal, the right to which is the creation of the statute